where we have covered the contract, types of contract, as well as we had discussed contract of guarantee and the contract of agency. So that we have already discussed in our unit number 1. So today we will be starting with unit number 2. Unit number 2 is the smallest and the easiest of the 5 units of legal aspects of business. Second unit is related to contract of sale of goods and extension of this we will be discussing in unit number 5 under Consumer Protection Act 1986 and 2000. So contract of sale of goods. I'll first read the definition and then we will discuss. Contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. Is my screen visible to all?
Yes, sir.
Okay, thank you. So contract of sale of goods is a contract where the seller transfers or agrees to transfer the property in goods to the buyer for a price. The simple meaning of contract of sale of goods. Next one is a contract of sale may be absolute or conditional. And the next one is when the goods are sold, the property in goods is passed from seller to the buyer, and as a result, the seller ceases to be the owner of the goods while the buyer becomes its owner. So, in simple words, we can say contract of sale of goods is a contract whereby the seller sells certain goods and buyer buys that good. Now, these transaction or this transaction of selling and buying shall be based on monetary consideration. A contract where the seller sells his product for a particular price to buyer is called as contract of sale of goods. Very simple. Suppose Mr. A wants to purchase a new mobile. He went to a electronic showroom. He checked various mobiles of his range and he selected one of the mobile. He asked the seller that I want to purchase this mobile. The seller told Mr. A, who is the buyer who wants to purchase a new mobile, that this price, this mobile will cost you 15,000 rupees. Mr. A pays 15,000 rupees and he gets the delivery or gets the possession of the mobile. And that is called as contract of sale of goods. Now here in this example, what has happened? The seller has sold the mobile to buyer for a price of 15,000 rupees. Now the last part of the definition says when the goods are sold, the property in the goods is passed from the seller to the buyer, and as a result, the seller ceases to be the owner and the buyer becomes its owner. Now, the moment the buyer pays the cost of the mobile, the price of the mobile, that is 15,000 rupees. The buyer becomes the owner of that mobile. Now, till the period when this payment of 15,000 is done by the buyer, seller will be regarded as the owner of that mobile phone. So all the mobile phones which are there in the electronic shop of seller, he will be considered as the owner of those mobiles. Who? The seller. But the moment the buyer has paid 15,000 rupees for that particular mobile, the ownership is passed from seller to buyer with respect to that mobile only. जो मोबाइल पसंद आया, जिस मोबाइल के लिए बायर ने 15,000 रुपए सेलर को दिए, जैसे ही उसने 15,000 रुपए दिए, सेलर अब उस मोबाइल का ओनर नहीं रहेगा. सीजेस मींस नहीं रहना. सो अब कौन होगा उसका ओनर? Instead of seller, now the buyer will be considered as the owner of that mobile. So a very important thing which you have to remember is meaning of transfer of property under contract of sale of goods. So whenever this term will be used in this unit number 2, contract of sale of goods, you have to understand it as transfer of property means transfer of ownership. So whenever you will come across this term, transfer of property under sale of goods, you have to always assume that it is transfer of ownership. And transfer of ownership takes place only when the price of the product is paid to the seller. Now, the definition also says that a contract of sale can be absolute or conditional. Again, very simple. Absolute means the entire price of the mobile is being paid by the buyer, that is Mr. A, and immediately A becomes the owner of that mobile. Now, contract of sale of goods can also be conditional. Conditional means that he is ready to pay 10,000 rupees now. 5,000 rupees he has promised the seller that tomorrow I will pay you 5,000 rupees. But the condition is that you have to give the mobile to me now, and I'll make sure that you receive 5,000 rupees tomorrow by afternoon. So this sale of goods will be called as conditional contract of sale of goods. Absolute contract of sale of goods means where the entire amount of the entire price of the product has been transferred from the buyer to the seller. That condition will be called, that will be called as absolute contract of sale of goods. Condition means where buyer or seller is putting certain conditions. So till the conditions are fulfilled, this particular contract will be called as conditional contract of goods, contract of sale of goods. And the moment these conditions are fulfilled, are complete, it will be called as absolute contract. So that is the meaning of contract of sale of goods. Very simple. In contract of sale of goods, two parties are involved. One party is called as seller who is selling the goods. The other party is called as buyer, who is ready to buy that goods. Now, how this deal should take place? So it is expected that there has to be monetary consideration, monetary transaction involved in the deal. If, as a buyer, I want to purchase a refrigerator, I have to pay the price of the refrigerator. Then only there can be a contract of sale of goods between the seller and me, the buyer. It can be absolute, it can be conditional. So that is called as contract of sale of goods. Now, there are certain essential elements of contract of sale of goods that we will be discussing. Number one is two parties. We have already discussed that at least two parties should be involved. There cannot be a contract of sale of goods with one person only. That person regards himself or treats himself as seller, and same person treats himself as or herself as buyer also. So that type of contract is not considered as a valid contract of sale of goods. For a valid contract of sale of goods, there has to be two parties. One party will be called as seller, who will be selling the product and or selling the goods, and the other party will be called as buyer, who will be purchasing or buying the goods. So two parties should be there. That is the first essential element of contract of sale. Second essential element is goods. That goods should be involved. And which goods? That I think last time also we had discussed that it should be movable goods. Immovable goods are not covered under the contract of sale of goods 1930. Immovable goods are covered under transfer of property. So as transfer of property is not included in our syllabus, so we will not discuss about the immovable goods. We will concentrate ourselves to only movable goods. So which type of goods should be there? Movable goods should be there. Refrigerator, movable. Then crops, movable. So any movable goods is included under the movable goods. Next is transfer of property. Now, I have already told you that whenever this term is used in contract of sale, you have to always take it as transfer of ownership. तो जब कभी ये टर्म यूज हो रही है कॉन्ट्रैक्ट ऑफ सेल ऑफ गुड्स में, हमेशा आपको इसको क्या ट्रीट करना है? कॉन्ट्रैक्ट सॉरी, इट इज ट्रांसफर ऑफ ओनरशिप. कि सेलर अब ओनर नहीं है, अब बायर ओनर बन गया है उस वस्तु का, उस चीज का, उस आइटम का, उस प्रोडक्ट का, उस गुड्स का. राइट? सो दैट इज transfer of property. There has to be transfer of property. Then only there can be, we can call the contract as contract of sale of goods. So seller, the transfer of ownership should be from seller to buyer. The moment buyer pays the price, the amount of or the cost of that particular good, then the seller ceases to be the owner of that goods, and now the new owner will be called as buyer. Buyer becomes the new owner. Next one, monetary consideration. Here again we have just discussed that money should be involved. Money transaction, monetary transaction should be involved. If anything is given for free, it will not be called as contract of sale. I went to purchase a refrigerator. The owner was a very close relative of mine. When I inquired with him about a refrigerator, he showed me various types of refrigerator. When I selected that I want to purchase this type, this model, and when I checked with the price, as he was very closely related to me, he said, no, I will not take any amount, any price from you. I will give you this refrigerator as free of cost. Free. So as the monetary transaction has not taken place, he has given me the bill in my name. So once I received the bill, technically I will be called as the owner of that refrigerator because the bill has been created in my name. But this type of contract will be covered under gift deeds. They will not be covered under contract of sale of goods. Why? Because one of the essential element of contract of sale of goods, that is monetary transaction, monetary consideration, is missing in this example. So money transaction should take place. Then only it will be called as contract of sale of goods. If even if the price of the refrigerator is say 20,000 rupees, and as the person was very closely related to me, the seller was closely related, he said that instead of 20,000 rupees from others, I am charging 20,000 rupees, from you I'll charge only 15,000 rupees. So here again, it will be called as contract of sale of goods. Why? Because monetary transaction has taken place. It doesn't mean it doesn't mean that the amount should exactly be 20,000. It can be 10,000. It can be less than that also. Only thing which makes it contract of sale of goods is that money transaction should be involved. कितने का फ्रिज है वो इंपॉर्टेंट नहीं है, फ्रिज के बदले में पैसा दिया गया वो इंपॉर्टेंट। जब फ्रिज के बदले में पैसा दिया जाएगा तभी वो कॉन्ट्रैक्ट ऑफ सेल ऑफ गुड्स होगा। तो ये सारे जब तक पॉइंट्स नहीं रहेंगे किसी भी कॉन्ट्रैक्ट में, तब तक वो कॉन्ट्रैक्ट सेल ऑफ गुड्स नहीं हो सकता। इफ गुड्स आर मिसिंग, देयर कैन नॉट बी अ कॉन्ट्रैक्ट ऑफ सेल ऑफ गुड्स। इफ मॉनेटरी कंसिडरेशन इज नॉट देयर, no contract of sale of goods. If transfer of property is missing, that is ownership is not taking place, then again it is not contract of sale of goods. Last one, last element for the contract of sale is essential elements of a valid contract. 9-10 elements of a valid contract that we had discussed in our initial sessions when we were talking about the definition of a valid contract. So all those essential elements as well as the above four elements should be present in all the contract of sale, then only it will be called as contract of sale of goods, otherwise it will not be. So these are the certain essential elements for contract of sale. Now we will discuss about goods or types of goods. Basically, there are two types of goods. One is called as existing good and the other one is called as future goods. Now the third one, contingent goods, is part of future goods. It is one of the type of future goods. Now existing goods, as The meaning itself clears everything. Existing goods. The goods which exist at the time of creation of contract of sale of goods are called as existing goods. ऐसे goods जो कॉन्ट्रैक्ट ऑफ सेल ऑफ गुड्स के समय उपलब्ध है, those goods are called as existing goods. I went to the electronic showroom to purchase a LCD. I checked various LCDs and I selected a particular model. I want to buy that LCD. So that LCD will be covered under existing goods because it is there in the electronic showroom. I have checked that, I have seen that, and I have finalized that I will be purchasing this model LCD only, this LCD only. So that good will be called as existing goods. क्योंकि जब मुझे वो खरीदना है, जब मुझे वो चुनना है, जब मुझे वो फाइनल करना है, तब मैंने देखा, उसके फीचर्स को जाना और अब मैं उसे खरीदना चाहता हूं. So this type of goods will be called as existing goods. Now under existing goods, again three subtypes are there. First one is called as specific good. The other one is called as ascertained goods. The last one is called as unascertained goods. Specific goods, as the name itself says, specific. So specific details have been given by the buyer to the seller that I want this model, this mobile phone, which should have this feature. It should be of this company and it should be in the range of this. So specific instructions are given or specific requirements are given by the buyer to the seller before purchasing that goods. And on the basis of those requirements, the goods are shown to the buyer and then the buyer purchases those goods. And that is called as specific goods. Now next one is ascertained goods, and opposite of that is unascertained goods. Ascertained goods means when you have finalized some models from a lot. 10 models of mobile phones were shown to you or shown to the buyer, and buyer is confused within 2-3 models. He has selected 3-4 models or 3 models, we will say. Now among these 3 models, he want to purchase one model. So these 3 models will be called as ascertained goods. Last one is unascertained goods. Unascertained goods means only on the basis of specification, only on the basis of requirement, the buyer is ready to purchase the goods. He has not seen the goods, he has not finalized the goods, he has given his requirement. On the basis of that requirement, he is ready to purchase the goods. Now that type of goods are called as unascertained goods. Now the next one is future goods. Again, very simple. The name itself says future goods. The goods which are not in existence now. they will reach the shop afterwards. They will reach the mall afterwards. They will reach the seller's place afterwards. So it is not there in the shop existing at present. So those goods are called as future goods. Now, for example, a buyer went to a car showroom to purchase a car. Now he checked various models and he wanted to purchase one of the car out of those models. When he was finalizing the deal with the salesperson, he saw a pamphlet or a photo of a car on one of the wall of the showroom. He just checked with the salesman that what about this particular car? What is the price? What are the features of this car? The salesman informed the buyer that this is the new model of the company, just launched or will be launched in 2-3 days. And if you are interested in this car, you need to wait at least for 10 to 15 days. Because it is in transit or it is in the factory itself, it is in the manufacturing process. So it will take at least 10-15 days to reach the showroom if you are interested in this car. And if there is a deal between that buyer and the company, that dealer, that okay, I'm ready to wait for 15 days. I'm ready to pay you the advance of 1 lakh rupees, 2 lakh rupees, whatever has been fixed between the buyer and the seller, that is the dealer of the car. So that type of contract where the car will reach, the goods will reach in future. Either they are in the manufacturing phase or they are in transit. That type of goods are called as future goods because it is not existing. It will reach the seller's place afterwards, maybe after 1 day, after 2 hours, after 4 hours, after 6 hours, after 3 days, after a month. But right now, at present, it is not there. As it is not there, it will be treated as future goods. Some after 1 day, after 2 days, after 3 days. Now the next one is contingent goods. Now the meaning of the word contingent is dependent upon. Contingent goods is not a separate type of goods as we have discussed the existing goods and future goods, but it is a subtype of future goods. And the meaning of contingent goods or the example for contingent goods is that one person deals with selling mangoes. Now he enters into a contract for sale of mangoes with the owner of mango farm, जिसका आम का बगीचा है, उसके पास जाता है और उसके साथ कॉन्ट्रैक्ट करता है. और कॉन्ट्रैक्ट क्या है? सेल ऑफ मैंगो, मैंगो बेचने का, कि आपके बागीचे में जितने भी आम आएंगे आपके पेड़ों पे, वो सारे आम आप मुझे बेचेंगे. जो भी उनका प्राइस होता है वो फिक्स हो जाता है और दोनों भी एक कॉन्ट्रैक्ट कर लेते हैं। जो फार्म ओनर है वो लिख के दे देता है कि मेरे जो 100 पेड़ है उसमें जितने भी आम आएंगे मैं सारे आम आपको दूंगा। अब contingent means dependent upon. Now this contract of sale is dependent upon what? The crop is not there yet. अभी तक नहीं आए हैं आम। आम जब आएंगे, जितने आएंगे सारे मैं आपको दूंगा। अब वो 1000 किलो हो सकते हैं, उससे ज्यादा हो सकते हैं, उससे कम भी हो सकते हैं। तो this type of contract which is contingent upon some event or future event, in future it is going to take place, it is dependent upon some future event। बीच में ही कोई रोग आ गया, कोई और प्रॉब्लम आ गया और सारी फसल बर्बाद हो गई तो वो कॉन्ट्रैक्ट कैंसिल हो जाएगा। तो ये कॉन्ट्रैक्ट कंटिंजेंट कॉन्ट्रैक्ट कहलाएगा। क्यों? बिकॉज दिस कॉन्ट्रैक्ट इज डिपेंडेंट अपॉन सम अनसर्टेन इवेंट। बिकॉज इन फ्यूचर जब आम आएंगे पेड़ पे, जब वो तोड़ेंगे, उसके बाद ये कॉन्ट्रैक्ट खत्म होगा। कॉन्ट्रैक्ट एडवांस में साइन हो चुका है। इट इज नॉट दैट द कॉन्ट्रैक्ट इज नॉट वैलिड, कॉन्ट्रैक्ट इज एब्सोल्युटली वैलिड, but contract will be covered under contingent goods of contract of sale of goods. So these are called as contingent goods. Now one more concept which we should be aware of is called as the concept of caveat emptor. The meaning of this Latin term caveat emptor is let the buyer beware. A seller is under no duty to reveal unflattered truths about the goods sold, and therefore, whenever a buyer buys the goods, he must exercise necessary care in his own interest. Now, before moving to this term or before discussing about caveat emptor, we will just discuss about the role and responsibility of seller under the contract of sale of goods. Very simple role. And the role says that whatever question the buyer is asking related to a particular goods or particular product, the seller is bound to answer those goods. Suppose buyer wants to purchase a ceiling fan, and while purchasing that ceiling fan, while finalizing the ceiling fan, the buyer is asking too many questions. कितने एम्पियर्स का प्लग होना चाहिए, सॉकेट कितने एम्पियर्स का होना चाहिए, कम एम्पियर का रहेगा तो चलेगा क्या, ज्यादा एम्पियर के इसमें प्लग डाला तो क्या होगा, इसका मोटर कितने वोल्ट का है, इसके जो 3 ब्लेड्स हैं उसका लेंथ क्या है, उसका विड्थ क्या है, इसका वेट कितना है, इसकी मोटर का वेट कितना है। तो ये सारे प्रश्न जो भी बायर पूछ रहा है खरीदने से पहले, ये सारे प्रश्न कंपल्सरीली इसके आंसर्स देने चाहिए सेलर ने। दैट इज एक्सपेक्टेड। जब तक बायर को वो सारे आंसर नहीं मिल जाते, जब तक बायर सेटिस्फाई नहीं हो जाता कि ठीक है मैंने 50 क्वेश्चन पूछने थे, 50 की 50 पूछ लिए, सेलर ने भी सेटिस्फैक्टरीली उसका आंसर दे दिया, अब मैं ये डील करना चाहता हूं। यहां पर सेलर ये नहीं बोल सकता कि 1000 रुपए का पंखा है और 5000 रुपए के अगर आप सवाल करोगे तो मैं नहीं बेचूंगा, या आप सिर्फ 2 सवाल करो और मैं 2 जवाब दूंगा, और 2 जवाब देने के बाद आपको ये खरीदना ही पड़ेगा। सो दिस टाइप ऑफ conditions cannot be imposed under the contract of sale by the seller. That is clear कि आप किसी भी बायर के ऊपर कोई भी सेलर दबाव नहीं डाल सकता कि आप मेरी दुकान के अंदर एंटर हो गए, गर्मी का सीजन है, आप मेरी दुकान में आए, मैंने आपको ठंडा पानी पिलाया, बिठाया, ठंडा पानी पिलाने के बाद आपको जूस पिलाया, और जूस पिलाने के बाद फिर आपको जो भी आपकी रिक्वायरमेंट के हिसाब से वो प्रोडक्ट दिखाया। अब क्योंकि मैंने आपकी इतनी आवभगत की है, तो अब ये कंपलसरी है कि आपको कुछ ना कुछ तो प्रोडक्ट मेरे दुकान से खरीदना पड़ेगा। ऐसा कंडीशन कोई भी सेलर नहीं लाद सकता बायर के ऊपर। दिस टाइप ऑफ कंडीशन कैन नॉट बी इम्पोज्ड। Here the buyer is having a right that he can select a product and he can ask as many questions as he wants or she wants before finalizing the contract of sale, before paying the amount for that particular goods or product. That is his right. Now the difference between this principle is very simple. It is based on that no seller can force the buyer to purchase a particular product. Now buyer went to the electronic showroom to purchase the washing machine. 3 washing machines were shown to the buyer by the seller, and the seller invested 15 minutes in showing the details of these 3 machines to the buyer. But buyer wanted to see more washing machines. There the seller said that no, we are having only 3 with us. You have to select at least one from this 3. So this type of binding cannot be imposed by the seller. It is up to the buyer to purchase or not to purchase. That is the simple principle, that you cannot force the buyer. Now the difference between this simple principle and the theory of Caveat-Emptor is that under Caveat-Emptor it is mentioned a seller is under no duty to reveal unflattered truths about the goods sold, and therefore whenever a buyer buys the goods he must exercise necessary care in his own interest. Unflattered truths means जितने प्रश्न बायर के पूछे हैं वो सारे तो सेलर को सॉल्व करने ही चाहिए, करने ही पड़ेंगे, तभी वो बायर खरीदेगा, नहीं तो नहीं खरीदेगा। पर बायर अगर कोई प्रश्न पूछता ही नहीं है, बायर गया कि मुझे एक सीलिंग फैन खरीदना है और ओरिएंट कंपनी का खरीदना है, सेलर ने 3 मॉडल दिखाए, बायर ने एक मॉडल पसंद किया और घर आ गया, प्राइस जो भी 1500 रुपए 2000 रुपए थे वो वहां पर पे कर दिए और बायर वो सीलिंग फैन लेके घर आ गया। 2 दिन के बाद जब सीलिंग फैन इंस्टॉल हुआ और जब ऑन किया बायर ने, तब उसे पता चला कि बहुत नॉइज प्रोड्यूस कर रहा है, बहुत ज्यादा आवाज आती सीलिंग फैन। तो बायर वापस दुकानदार के पास, सेलर के पास गया और उसे कहा कि जब आपने ये बेचा तब आपने पूरी जानकारी मुझे नहीं दी। तो यहां पर द सेलर इज प्रोटेक्टेड अंडर द थियरी ऑफ केविट एम्प्टर टू दी टू सम एक्सटेंट, टू सम एक्सटेंट। तो एक्सक्यूज मिल सकता है सेलर को, पर पूरा नहीं, सम एक्सटेंट। अनफ्लैटर्ड ट्रूथ्स, अनफ्लैटर्ड ट्रूथ्स मीन्स माइन्यूट डिटेल्स उसे बताने की जरूरत नहीं है अगर बायर नहीं पूछ रहा है तो, पर जो मेजर पार्ट है वो उसे बताना ही चाहिए। अगर सेलर को ये पता है कि ये फॉल्टी पीस है या फिर इस फैन में आवाज ज्यादा आती है, तो ये चीज बायर को खरीदते समय बतानी ही चाहिए। अगर नहीं बताई गई तो दिस इज कंसिडर्ड एज अ मेजर थिंग। कोई भी अगर सीलिंग फैन खरीद रहा है तो वो ये चाहेगा कि हवा अच्छी आए, आवाज कम आए। हवा कम आ रही है, आवाज ज्यादा आ रही है, मींस मेजर जो ऑब्जेक्टिव है that is violated, that is broken. So here the excuse is not under caveat emptor for the seller. Caveat emptor says that unflattered truths means minute details, if not shared then it is okay, but major part तो शेयर करना ही चाहिए। अब उसके माइन्यूट डिटेल्स अगर शेयर नहीं किए गए, जैसे कि कितने वोल्ट का उसका मोटर है, अगर ये नहीं बताया गया तो भी चलेगा, क्योंकि वो माइन्यूट डिटेल है। अगर कोई पूछ नहीं रहा है, माइन्यूट डिटेल्स नहीं बताए गए, देन द सेलर इज प्रोटेक्टेड अंडर द थियरी ऑफ केविट एम्प्टर। बट इफ the major objective of buying that particular product is violated, is broken, then this theory of caveat emptor does not protect, do not protect the uh, seller. So that is the meaning of caveat emptor, कि सारी बारीक बारीक चीजें अगर पूछी नहीं गई हैं तो बताने की जरूरत नहीं है, पर इसका ये मतलब नहीं है कि उसने कुछ भी नहीं पूछा तो आप उसे कुछ भी दे देंगे। अगर सेल का मेजर ऑब्जेक्टिव वायलेट हो रहा है, तो थियरी ऑफ केविट एम्प्टर कैन नॉट प्रोटेक्ट द सेलर। सेलर हैज टू कॉम्पेंसेट द बायर। बहुत आवाज कर रहा है, हवा कम आ रही है सीलिंग फैन, तो वो सीलिंग फैन उसे बदल के देना पड़ेगा या फिर उसे वो कॉम्पेंसेट करके देना पड़ेगा। यहां पर केविट एम्प्टर कैन नॉट प्रोटेक्ट। यहां पर वो सेलर ये नहीं बोल सकता, अगर आप पूछते बायर को, सेलर कभी भी ये नहीं बोल सकता कि अगर आप पूछते तो मैं आपको जरूर बताता कि ये सीलिंग फैन हवा कम देता है और आवाज ज्यादा। So that type of violation is considered as major violation. So for under this condition, the interest of the seller is not protected. But if some minute details are missing, if some minute details are not shared with the buyer, then it is not say violation of the concept of caveat emptor. फॉर एग्जाम्पल, एक बहुत सिंपल एग्जाम्पल, सपोज हम लोग अगर आयन लिया, एक इस्त्री प्रेस जिससे हम लोग कपड़ों को प्रेस करते हैं, अगर प्रेस ली तो प्रेस के ऊपर बहुत सारे ऑप्शंस रहते हैं। जैसे ये कॉटन, वो बटन हमारे को घुमाना पड़ता है कॉटन पे, फिर सिल्क है, कॉटन है, या और भी कई टाइप के जो क्लॉथ्स रहते हैं उसके ऑप्शंस रहते हैं। अब सपोज अगर मैं बायर हूं और मैंने एक आयन, और मैं अपने जो मेरा कॉटन शर्ट है उसको ये कर रहा हूँ, या सिल्क का कोई कपड़ा है जिसे मैं आयन कर रहा हूँ, और मैंने ये ध्यान नहीं दिया कि किसके ऊपर रखना चाहिए, ये मैंने सिल्क के ऊपर वो नॉब घुमा के रखना चाहिए ताकि वो जले नहीं। वो नॉब जो था आयन का वो कॉटन पे रहा, और जैसे ही मैं सिल्क को आयन करने गया वो सिल्क जल गया। अब यहां पर अगर मैं सेलर के पास जाता हूँ और सेलर को बोलता हूँ कि आपने जब मुझे आयन बेची तब आपने ये मुझे नहीं बताया कि अगर आप सिल्क का कपड़ा कर रहे हैं तो नॉब सिल्क की तरफ रखिए, अगर आप कॉटन का कपड़ा प्रेस कर रहे हैं तो आप नॉब को कॉटन पे रखिए, जिससे आपका कपड़ा जलेगा नहीं। Now this particular things are considered as that when the buyer is purchasing a particular product, he should take necessary care while purchasing that product, and he should be aware of the functioning of that product. If he is not aware of that, then the best option available to the buyer is he can ask n number of questions till the buyer is satisfied. अब मुझे पता है कि नॉब इधर करूंगा तो कॉटन होगा, इधर करूंगा तो सिल्क होगा, जब सिल्क करना है तो सिल्क पे रखना है, जब कॉटन करना है तो कॉटन पे, मुझे पता है। पर फिर भी अगर मैं करता हूं और फिर अगर कुछ नुकसान होता है तो नुकसान भरपाई देने की जवाबदारी सेलर की नहीं है। यहां पर सेलर इज प्रोटेक्टेड, राइट? So that is the meaning of the term, or it is also called as theory of KV tempter. Now the next one is transfer of property or ownership. There are three stages in the performance of contract of sale by the seller, which are transfer of property in the goods, delivery of goods or transfer of possession of goods, and the last one is possession, or sorry, the passing of risk. So the first point is called as transfer of property in goods. Now I have told you earlier also that whenever transfer of property is used, it means transfer of ownership. So here we are discussing about transfer of property or ownership, when it takes place. कब होता है ट्रांसफर ऑफ प्रॉपर्टी? मुझे फ्रिज खरीदना है, जब मैं पैसे दूंगा उस फ्रिज के, तब होगा ट्रांसफर ऑफ प्रॉपर्टी। या फिर जब दुकानदार उसके गोडाउन से वो फ्रिज उठा के मेरे घर पर डिलीवर कर देगा, तब होगा ट्रांसफर ऑफ प्रॉपर्टी। So that thing we need to understand. So the answer is very simple. Transfer of property or transfer of ownership takes place the moment the monetary transaction takes place. I have paid 20,000 for that refrigerator. The seller has created or generated bill in my name, that Mr. So and so has paid 20,000. Mr. Buyer has paid 20,000 for this refrigerator. So when the bill is generated, when I have paid 20,000 rupees, I will become the owner of that refrigerator. Now the fact is that the refrigerator is still present at the godown of seller. Seller has promised me that within 2 hours, I'll make sure that fridge reaches your place. I have given the address to the seller. So in this case, when I have paid 20,000 rupees, when buyer has paid 20,000 rupees, immediately we will say that the transfer of property has taken place in this example. We will not wait for the physical installation of the refrigerator at the buyer's place. The moment bill is generated, the moment it is paid by the buyer is now the owner of that refrigerator. Now the seller ceases to be the owner of the refrigerator. Now it will be assumed that buyer's refrigerator is kept in the go down of the seller. Now that refrigerator which is there in the go down of the seller is owned not by the buyer, not by the seller, but it is owned by the buyer. Why? Because buyer has paid the amount. Later on, it will reach the buyer's place. So that is the meaning of the first point, that is transfer of property in goods. So transfer of property in goods or transfer of ownership in goods takes place when the money is or monetary transaction takes place in the contract of sale of goods. Now the next one is delivery of goods or transfer or possession of goods. And the last one is passing of risk. We will stop here, and in the next session we will continue with these two points, and then we will talk about the performance of contract of sale, and also we will be discussing about the delivery of goods or types of delivery of goods. Under that, actual delivery, symbolic delivery, and constructive delivery we will be discussing. So thank you everyone for being present for today's session. In the next session, we will continue with the types of goods and types of delivery. Thank you.
Hello.
Thank you, sir.
Sir,
Yes.
hello sir. Thank you for your valuable time. सर एक विचारायचं होतं आपले काही ऑफलाईन क्लासेस सुरू होण्याचे काही पॉसिबिलिटीज आहे का?
Come again. Hello.
आपले ऑफलाईन कॉलेज सुरू होण्याचे काही पॉसिबिलिटीज आहे का सर?
Yes, there are possibilities. All the possibilities are there. We are waiting for the government written notification. As and when we will receive those notifications, then we will discuss about this, and we will update you when we can start with the offline classes. क्योंकि हमारे को भी ऐसा लगता है कि ऑफलाइन जल्दी से जल्दी शुरू होने चाहिए, पर बहुत सारे रूल्स एंड रेगुलेशंस हैं that need to be followed. We need to check how many of you are total complete vaccinated. That means how many of you have taken double doses, because when at the beginning means I think around induction program we had taken this information also. At that time only I think 30 to 40 students were the complete vaccinated, जिन्होंने दोनों डोज ले लिया था. ऐसे 30 to 40 स्टूडेंट्स ही थे. तो अभी हमारे को वापस से वो चेक करना पड़ेगा, बिकॉज वी नीड टू फॉलो दोज इंस्ट्रक्शंस ऑफ द गवर्नमेंट वेरी सीरियसली, कि वही स्टूडेंट्स कॉलेज में आ सकते हैं जिनका डबल वैक्सीनेशन हो गया है. आपको वो सर्टिफिकेट हमेशा अपने बैग में रखना पड़ेगा, कि कभी भी अगर रैंडमली चेक हुआ यूनिवर्सिटी अथॉरिटीज से, तो ना आपको प्रॉब्लम हो, ना कॉलेज को प्रॉब्लम. तो ये सारी चीजें हमारे को चेक करनी पड़ेंगी. और क्या क्या रूल्स हैं यूनिवर्सिटी जैसे जैसे हमारे को बताएगी, वैसे वैसे हम लोग आपको बताएंगे, और जितना जल्दी हो सके वी विल ट्राई टू स्टार्ट विद दी offline classes also. No worries in that. Okay.
Okay, sir. Thank you.
Okay. Thank you. Okay. Bye.